Good afternoon, everybody. Thank you for joining us. We're just waiting for the delegates to come in. Thank you for your time and spending part of your afternoon with the African Labour Law Society. We appreciate the support. Great. I'm going to start with the introductions. The session is being recorded, and we will share the recording and the presentations done by Moemedi and Jackie with the delegates, so you will be able to review it later. I'm Claire Fincham. I'm one of the management committee members of the African Labour Law Society. The African Labour Law Society has been going since 2017, and we've held 6 conferences around the continent, and we have 300 members and about 1,500 people on our database. We have country representatives, and we run webinars and share material on a weekly basis with our members from various jurisdictions around the continent. We have other membership benefits, and if you're not a member, we really encourage you to join. It is only $30 for the year, 600 Rand. I'm going to quickly introduce the speakers. First, Moemedi Tafa. He is in Botswana. He's a partner at Armstrongs law firm, and he's also the president of the African Labour Law Society. And then we have Keshni Naicker. She is the vice president of the African Labour Law Society, and she is a partner at Bowmans law firm based in South Africa. The Bowmans has a lot of offices around Africa as well. And last but not least, Jackie Jhala. She is at the Corpus law firm in Lusaka in Zambia. She is our country representative of the Zambian group of members for the African Labour Law Society. I'd like to thank them for their time, their continuous support of the society, and for sharing their expertise this afternoon. So over to you, Moemedi, and thank you everybody for joining us. Oh, I wanted to say, if you have questions as we go along, please put them in the question and answer tab at the bottom. There is also an opportunity to chat in the chat, and then we will take questions after the 3 presentations have taken place. So please use the question and answer tab to pop your questions in as we're going along. Thanks, Moemedi. Over to you.
All right. Thank you very much, Claire. Good afternoon to everyone. Thank you once again for joining us this afternoon. We really do appreciate it. As you would have now been aware, I'll be speaking to the topic of this afternoon being regulation of fixed-term contracts, and it being a comparative perspective between Botswana, South Africa, and Zambia. And I think I'll just get straight into it. The first point of commencement, as you'd see there from this screen, is oftentimes what we've established is that there is a misappreciation as to what a fixed-term contract is, or what forms fixed-term contracts do take. And unfortunately, these realities become apparent when there are disputes that have now arisen. As you can see from the screen, we've identified specifically 2 types of fixed-term contracts, being a limited duration contract and one of a specific project. Now, when one speaks of a limited duration contract, it's quite simplistically put as one contract that commences on a particular date and ends on a specifically identified date. The unfortunate reality is it often happens that even when such a contract does provide for a limited period of its duration, that employees commonly find themselves quite confused because the corporation or entity or the employer, even after the period has lapsed, still exists. And that often is a result of a failure by the employer to explain the exact nature of what a fixed term contract is, which is limited to a particular duration. The second form of limited fixed term contracts are those of a specific project, or those that are sometimes referred to as milestone bound. Now, these are equally confusing. And these at times are instances where a specific contract is limited to a certain deliverable. Now, what we commonly find is once that deliverable has been achieved, once again, employees still face the often hard to accept reality that the employment has come to an end. But once again, these are the harsh realities that arise because of limited appreciation of the forms of fixed-term contracts. Now, in Botswana, we find that in most instances, these confusions arise because of the limited statutory restrictions. Our employment regime, our employment legislative framework has largely left it to employers and employees to agree on what would suit them in terms of their working regime. There are very limited instances that you would find that the courts can actually intervene in stating what exactly an employer must put into a fixed-term contract. To the extent that a contract provides for the bare minimums, and in this instance in Botswana, your bare minimums generally entail having a notice period in the employment contract. They entail specifying the working hours. They entail an entitlement to severance pay, for example. But anything else in between, unfortunately, our legislation in Botswana does not protect or provide adequate avenues for employees to be protected. There are no statutorily imposed durations. What do we mean by this? The reality is an employment contract of a fixed term nature can even be for 1 month, can be for 2 months, can be for 3 months, can be for 10 months. There are no restrictions with respect to how long a fixed term contract must be. But when one looks at this, and this is really what is important when one looks at fixed term contracts, particularly within our context here in Botswana, is who actually benefits in terms of putting in place a fixed term contract. I have been fortunate enough over the years to have acted for employers in 99% of the matters I've done in the courts. And I can assure you from my client's perspective is that they prefer fixed term contracts. And it is a harsh reality that we find ourselves in, particularly in an African context, that we find that employers generally prefer having fixed term contracts primarily because they are the easiest forms of contracts to exit from. There are limited extensions of liability. There are limited risks associated with fixed term contracts. Now, when one looks at this now from an African perspective, not necessarily just zoning into Botswana alone, one finds that this is what I sometimes refer to as an African continental curse. And this is because what often happens is that because of the need for investment in Africa, it is often a prerequisite for the working environment, the labor regime, the human capital regime to be as easygoing to hire and fire, such that it enables potential investors to get their money's worth as and when they so desire. And what are the protections afforded to employees under Botswana's legislative framework? Unfortunately, save for the bare minimums, such as being entitled to be paid, such as being entitled to a severance benefit, such as being required to have specified working hours, there are not much protections that do exist under our current legislative framework. So in the event that the employer does not feel the need to include additional benefits or additional incentives under the fixed term contract, it is very unfortunate that in most instances, employees find themselves largely abandoned at the time that the employment relationship is terminated. What happens in the instance, for example, where employees' employment contracts are terminated under a fixed-term regime which does not provide for much? The sad reality is there is very little that an employee can do in such an instance. What are the benefits to employees under fixed-term contracts, or rather to employers? Well, employers have quite a few advantages at their disposal. And most importantly to this, for employers, is the ability to exit such obligations at will. In most instances, employers will go out to include limited notice periods or the bare minimums. In most instances, you get employers that will simply go out to restrict the amount of benefits that could be extended to employees. So in essence, and I always say, the fixed-term contract, in my humble view, was never intended for the benefit of employees. It is a contract that is essentially aimed at affording employers the latitude, the flexibility, and the ability to be in control. And with the absence of statutorily imposed time periods or durations, one finds that employers are in most instances quite confident and are protected by the law to give out such contracts at whim, limiting it to, in some instances, 5 months, some instances up to 12 months, simply looking at the needs of their particular employment or their particular operations. But in essence, and this is where employers find that the fixed-term contract is in essence a beneficial contractual regime. One can imagine instances where an employer who is simply in the country for a particular project goes ahead and enters into fixed-term, into long-period contracts or indefinite period contracts, which simply do not match with the duration for which an employer will be in a particular jurisdiction. So the mechanisms under a fixed-term contract undoubtedly enable such an employer to exit as and when the need does arise. Now, bring it back now to Botswana with respect to legislative transformations. I've entitled this particular slide as Political Will. Botswana at the present moment is in the process of actually going through what is most likely to be one of the most transformative promulgation of legislation on the employment law front. As we speak now, a second reading of the proposed labor legislation has gone through Parliament and has passed. What does appear to be a reality now in Botswana is that there appears to be a political will towards moving in the right direction, towards affording some degree of protection to employees that might be placed on fixed-term contracts. What we have found in the new act that's coming into place, if indeed it is passed into law, is that the law now seeks to put employers in a very somewhat strict position of having to state why they are putting employees on fixed-term contracts and why it is necessary in the event of a termination to indicate the base for that termination. So in essence, what the law seeks to now do in Botswana is to protect employees from being put willy-nilly on employment contracts of a fixed-term nature. Should this law pass and become effective in Botswana, what we will definitely see is a great migration through legislative provisions of having employees no longer being placed on fixed-term contracts, except, of course, where the circumstances do indeed dictate so. So this undoubtedly is a positive move towards the protection of employees who may find themselves in a current position of a fixed-term contract. Economical considerations. Do fixed-term contracts raise financial benefits to employees? What we often find and it is indeed a sad reality, is that fixed-term contracts unfortunately place great burdens on employees. Employees, for example, find it extremely difficult to secure finances to achieve any form of personal financing for whatever they might seek to do. For example, the moment an employee steps into any financial institution, the request to simply provide the employment contract clearly indicates the burden that relies on them with respect to the limited duration of the employment contract. So what this new law essentially aims to do is to, in fact, open up the avenues for such employees to possibly find themselves more exposed and more aligned to engaging in financial benefit avenues opportunities. What we also do realize is that, unfortunately, because of the limited nature of fixed-term contracts, employees find themselves extremely dependent on their employers. And it is unfortunate in most instances, as is the norm due to certain challenging economical circumstances, employees oftentimes are merely afforded the bare minimums. And in the absence of a legislative framework, it is often the case that such employees have no right of recourse elsewhere. The most important topic, as you see from the slide in front of you now, is can this power struggle between socio-economic considerations, economic factors, and international investment be won in favor of employees? As I indicated earlier, the unfortunate reality, which is a curse that I often say is a curse that berides the whole of Africa, is the need of investment into Africa. It is the desire of most African states to find themselves in positions where they are able to lure in international financing, international investment into their own domestic economies. And what is often the case, and Botswana is not immune to this, is that often the times international investment opportunities come with stringent requirements. The easier it is to hire and fire, the more likely it is that you would be able to attract foreign direct investment in your country. And that, unfortunately, has most instances resulted in the unfortunate dilemma of there being a lack of political will for employers to come into a country and actually provide more than exceptionally favorable terms and conditions to such employees. So in the absence of political will, in the absence of a balancing between socio-economic considerations and economic factors, same could result in a clear position where employees, unfortunately, will never find themselves able to win this constant power struggle between socio-economic considerations and international investment in Africa. This reality, unfortunately, is a live and real reality that, unfortunately, employees have to struggle with. And it requires an immense balancing exercise between such needs of employers and employees. The converse, unfortunately, also applies, that as business, as employers, one would need to ensure that they are placed in an economically suitable and favorable environment to ensure that as a potential investor, employer, you are actually able to make some form of return. It would not make sense to any potential investor to move into a jurisdiction where the human resource capital is so demanding, so expensive, that the margins of profit, unfortunately, simply do not match the extent of capital invested. So it is this unfortunate power struggle that oftentimes results in fixed-term contracts being the more preferred arrangement for most employers that seek to invest in African states. And Botswana, unfortunately, is not immune to that. And just in summary, as I commenced my brief engagement earlier, it is my view that the fixed-term contract was never intended to be in favor of employees, not at least in Botswana with the current legislative framework, which raises very minimal benefit, which raises very minimal incentive for employees to actually want to be associated with such types of contracts. And in the absence of political will, and the absence of a balancing exercise between the power struggle befalling socio-economic considerations and international investment, I believe that there will be a one-sided slant towards investors trampling over the interests of their employees. And with the limited time, and I will be prepared to take questions towards the end of the session, I would like to just briefly end here and allow my colleagues to take part in the further discussion. I thank you.
Thank you, Moemedi. That was excellent. Just a reminder to those who have just joined us that you can put your questions in the Q&A box at the bottom of the screen, and we will take the questions afterwards. And a reminder that we will be sharing the recording and the slides with the delegates after the webinar. Over to Keshni Naicker. Thank you very much for your time.
Thanks, everyone. Good afternoon. So from a South African perspective, Moemedi, it's a stark difference to the situation you've described. Just going straight into it, we've had amendments which took effect on the 1st of January 2015, and those were amendments to the Labour Relations Act, which we all just refer to as the LRA. And those amendments seek to regulate fixed-term contracts of employees who earn below the earnings threshold, to provide those employees with greater protection. That earnings threshold is set by the Minister of Labour from time to time, and that's done in line with the Basic Conditions of Employment Act. Currently in South Africa, the earnings threshold is 261,748 Rand and 45 cents per annum. So I'll just get into what the implications of that section is. The main protection which the LRA provides to employees falling under Section 198B is that an employee who is on a fixed-term contract, which is concluded or renewed in contravention of the provisions set out in Section 198B of the LRA, will be deemed to be employed on an indefinite basis. So in South Africa, we have what we call a deeming provision in respect of fixed-term contracts of employment. In particular, Section 198B of the LRA states that an employer may only employ an employee who earns below the earnings threshold on a fixed-term contract or successive fixed-term contracts for a period of up to 3 months. So our law is very specific insofar as the duration being up to a period of 3 months. Where an employee who earns below the earnings threshold is employed for longer than 3 months, the employee is deemed to be employed for an indefinite period, unless the nature of the work for which the employee is employed is of a limited or definite duration, or the employer can demonstrate any other justifiable reason for fixing the term of the contract. And I will later on deal with a few justifiable reasons. So to summarize up until this point, the Section 198B protection applies to employees earning below the BCEA threshold, so therefore excludes those who are considered high earners in a South African context. It also excludes small and new businesses, and it excludes statutory or collectively agreed fixed-term contracts. Moving on then to justifiable reasons for fixed-term contracts. Employers must have valid and written reasons for using fixed-term contracts longer than 3 months. And I'll go through some examples of what is considered a justifiable reason. A justifiable reason would include replacing another employee who is temporarily absent from work, such as in the case of maternity leave. Where an employee is employed on account of a temporary increase in the volume of work, which is not expected to endure beyond 12 months. So typically where you're dealing with an industry where there's a surge in the volume of work, maybe over the festive season, for example. It's common for employees to be employed on fixed-term contracts just to enable the business to handle that surge in the volume of work. A student or recent graduate who is employed for the purpose of being trained or gaining work experience in order to enter a job or profession. An example there is of your candidate attorneys who are employed on a fixed-term contract for more than 3 months, is employed to work exclusively on a specific project that has a limited or defined duration, or a non-citizen who has been granted a work permit for a defined period. It also does not apply, or a justifiable reason exists where the employee is employed to perform seasonal work, or employed for the purpose of an official public works scheme or in a job creation scheme, or is employed in a position which is funded by an external source for a limited period of time, and lastly, has reached the normal or agreed retirement age applicable in the employer's business. So those are examples of justifiable reasons. If none of those justifiable reasons exist and the employee earns below the threshold, the employee is deemed permanent after 3 months. I do have some case law examples. I'm not going to deal with the citation, but they're in a case involving the Enforced Security Group in 2017. Security guards were employed on rolling fixed-term contracts. So when we refer to rolling, we mean that the fixed-term contracts were continuously renewed. The Labour Appeal Court held that if a valid reason exists, example, there was a project-based work, then the contract is not automatically indefinite. And the lesson from that case is that employers must clearly document the reason for the fixed term of the contract. Another case is the one of assigned services, which I think from a South African perspective, most of us are familiar with. That was a 2015 case. And the difference there is that the employees or the workers were placed at a client for more than 3 months via a labor broker. And in that case, the Constitutional Court ruled that after 3 months, the client becomes the deemed employer. And the lesson we learned from this case is that Section 198B can also protect vulnerable workers from indefinite temporary placements where they're being engaged through a labor broker. The practical implications of the section for employers is that employers must also always be mindful to justify fixed-term contracts in writing and avoid rolling over of contracts without cause. Now, I mentioned at the beginning that Section 198B applies to employees who are earning below the threshold. This does not exclude employees who earn above the threshold from certain protections from a South African perspective. Where employees earn above the threshold set by the minister, there are still risks. And this is because the definition of dismissal in Section 186 of our Labour Relations Act has been extended to include a situation where an employee employed on a fixed-term contract of employment reasonably expected the employer either to renew a fixed-term contract of employment on the same or similar terms, but instead the employer offered to renew it on less favorable terms or did not renew it at all. Or in the second instance, where the employee reasonably expected the employer to retain the employee in employment on an indefinite basis, so on a permanent basis, but otherwise on the same or similar terms, but the employer offered to retain the employee on less favorable terms or did not offer to retain the employee. So we see from a South African perspective, the LRA offers protection not only to those earning below the threshold, but also to those earning above the threshold. When an employee alleges that they had a reasonable expectation for their fixed-term contract to be renewed or for them to be retained on a permanent basis, it is the employee who bears the onus to prove that they had a reasonable expectation. So for an employee to successfully rely on their definition, they must establish, one, subjectively that he or she had an expectation that the contract would be renewed. Two, that that expectation was objectively reasonable. And three, that the employer did not renew the contract or renewed it on less favorable terms. Now, obviously, that expectation must be measured on an objective basis, considering the employee's subjective expectations. So in order for that expectation to be reasonable, there must be an objective basis for the creation of his or her expectation. The court will not merely accept a subjective say-so or perception. And the courts in South Africa have adopted an objective inquiry in determining whether the expectation was reasonable. And in essence, what that entails is a test wherein the employee must prove the existence of facts that in the ordinary course would lead a reasonable person to anticipate renewal. So a number of factors will be considered in relation to the inquiry of whether there was indeed a reasonable expectation of renewal. And some of those factors include the terms of the contract, the past practice of renewals, the nature of the employment, and the reason for a fixed-term contract. And importantly, any assurances that the contract would be renewed and that failure to give reasonable notice of non-renewal of the contract. Now, interestingly, what we need to note here is that in as much as the fixed term, and as much as the contract might state that it is on a fixed term basis, a court, when a dispute is raised, will also consider the surrounding circumstances and whether anyone in that organization made any assurances to the employee that their contract would be renewed. And this was dealt with in a case involving Mediterranean woolen mills, where the court held that a reasonable expectation may exist, even if the contract expressly stipulates that the employee fully understands that he has no such expectation. And the court in a case involving SA Rugby clarified that the mere fact that an employee acknowledges at the time of signing his or her employment contract that they have no expectation of renewal does not preclude that employee from subsequently forming an expectation when changed circumstances justify it. So Moemedi, I think it's quite a stark contrast to what you explained or what you took us through from a Botswanan perspective. And I'm interested to hear what Jackie has to say from her perspective.
Thank you, Keshni. I appreciate your time and your expertise. Thank you to those who have put their questions in the chat. We will answer them after Jackie has done her presentation. Thank you, Jackie. If you could share your slides. And just a reminder for those who have recently joined us, you can put your questions in the question and answer box or in the chat box, and we will be sharing the recording and the slides with you all after the event. Over to you, Jackie. Thank you very much.
Thank you. Just give me a moment.
Thank you. We can see your slides.
You can see my slide. Okay. Let me just turn on my video. Okay. I think in the interest of time, I'll just keep the introduction, the objectives, and this is just a brief outline of my presentation. I'll mainly look at the different types of fixed-term contracts in our Employment Code Act. I'll also look at peculiar benefits under these fixed-term contracts. I'll briefly speak to termination of fixed-term contracts. I'll touch on renewals and just sum it up with some practical considerations. So the primary legislation on our end, which deals with fixed term contracts like any other contract of employment, is the Employment Code Act. And there is some subsidiary legislation as well, which employers may want to note as well. Specific to fixed term contracts, you would be looking at the Employment Code Exemption Regulations, which I've abbreviated as exemption regulations. And then depending on the sector an employer operates under, there are various employment orders. For instance, the Employment Code, Minimum Wages and Conditions of Employment General Order. So depending on the sector, for instance, if you own, you're in retail, there's a shop workers order. If you're in the trucking business, there's a trucking order. Those equally have additional terms and conditions you'd want to consider. To mention as well that these orders are not specific to fixed term contracts of employment. They apply generally to all contracts of employment. So straight getting into it, so the Employment Code Act does not define a fixed term contract, but it distinguishes between two types of fixed term contracts, a short term contract and a long term contract. So the Employment Code Act defines a short term contract, and in this context, a fixed term contract, to mean a contract whose duration does not exceed 12 months. And a long-term contract, on the other hand, is defined to mean a contract whose duration exceeds 12 months and can be renewed for a further term, or a contract for the performance of a specific task or project to be undertaken over a specified period of time and whose termination is fixed in advance by both parties. So generally, under the Employment Code Act, you would have a short-term contract, not more than 12 months, and then a long-term contract whose duration exceeds 12 months. Relevant as well to this discussion is permanent contracts, and whether a permanent contract, the usual language we would call them by in Zambia is a permanent and pensionable contract, whether this qualifies as a fixed term contract for purposes of the Employment Code Act. This distinction is relevant, especially when we come to talk about the peculiar benefits under a fixed term contract. So a permanent contract is defined in the Employment Code Act to mean a contract of employment if not terminated in accordance with the Act. It comes to an end when an employee reaches the retirement age as specified under our applicable pension laws. And this position as well has been reiterated by the court in several cases. I've cited one case here. I will not read exactly what the court stated. We'll share the slides, but effectively the court came to the conclusion that a permanent contract does not qualify as a fixed term contract under the Employment Code Act because it does not have a specific defined end date. The court also sought to state that even if you have retirement as when an employee ordinarily stops work, retirement is not really considered as an end date for purposes of the Employment Code Act because the law allows for different types of retirement. You'll have early retirement, you'll have normal retirement, or you have late retirement. So basically, for purposes of the Employment Code Act, a permanent and pensionable contract does not qualify as a fixed term contract. And now moving to peculiar benefits to fixed term contracts. Specific again, we've distinguished between short-term contracts and long-term contracts. Now, the Employment Code Act uses different terminology. You have gratuity and then you have severance. But when we go through the slides, you will note that the computation of gratuity or severance, as the case may be, is effectively the same. So to avoid confusion, I would just usually say gratuity, even though for short-term contracts, the correct terminology should be severance. So with respect to gratuity, the Employment Code Act does define gratuity in Section 3, and the definition is there. So effectively, gratuity, this is a payment made to an employee in respect of a person's service on the expiry of a long-term contract. You can see the tie to a long-term contract there. And it's based on basic pay, earnings that have accrued during the term of the contract. And then moving on to Section 73, which goes into the detail now to explain how gratuity is payable with respect to long-term contracts. So Section 73(1) states that at the end of a long-term contract, gratuity is payable to an employee at the rate of not less than 25% of the employee's basic pay earned during the contract period. So it's important to note here that when you're computing gratuity, you're not computing it based on the last salary of the employee, but based on the basic pay earned during the life of the contract. 73(2) goes to state that if the contract terminates prior to its expiry or it reaching full maturity, then you would have to prorate your gratuity. So the Section 73 speaks to gratuity with respect to fixed-term contracts whose duration exceeds 24 months. Now, when we move to short-term contracts, these are contracts whose duration, like I said, does not go beyond 12 months. So the Employment Code Act defines a severance. So the language here used is severance as opposed to gratuity. So a severance is defined as the wages and benefits paid to an employee whose contract of employment is terminated in accordance with Section 54. Now, when you look at Section 54 of the Act, it brings out different scenarios as to when a contract can terminate and when severance is payable. For purposes of this discussion, of relevance would be Section 54(1)(b) and (c), which I have highlighted there. So effectively, what these sections equally provide is that where short-term contract terminates before its maturity, you will prorate the severance pay, and you will notice the language. The severance pay shall be a gratuity at the rate of not less than 25% of the employee's basic pay earned during the contract period. So same computation as long-term contracts, no difference there. So if the contract terminates earlier, you will prorate. B, if the contract reaches its maturity date, you will pay based on the full period. So basically, those are the two sections which talk about the payment of gratuity. And as well, to note that the Section 54 does not apply, again, of relevance to permanent contracts. The Section 54 we've looked at does not apply to casual employees. It does not apply to employees engaged on a long term. So if you remember the definition of long term, it's a fixed term contract as well, but that is dealt with in another provision of the Act. And specific to permanent contracts, the court again clarified in the Kingfred Peary case that a permanent Section 54(1) does not apply to permanent contracts. The same reasoning as in the earlier case, basically that a permanent contract is not a fixed term contract as envisaged under the Employment Code Act, and as such, this section does not apply to it. So you will note that under both provisions, whether under long term or under short term, permanent contracts are expressly excluded. So therefore, meaning that if you are engaged on a permanent and pensionable basis, then you would not be entitled to gratuity. to mention here again that this is the main distinction really when you're considering fixed term contracts or permanent contracts. Under the Employment Code Act, everything else is effectively the same. There's really not much of a material difference with respect to the benefits an employee would be entitled to under a fixed term contract with respect to those under a permanent and a pensionable contract. However, because fixed term contracts have a limited period, certain benefits under the Act may not be accessed depending on the benefit you're looking at. I can give an example. For instance, if you're talking about paid maternity leave as an example. So every female employee is entitled to maternity leave, but the question is whether the maternity leave is paid or not paid. Now, what the Employment Code Act states is that an employee is entitled to paid maternity leave if that employee has served with the employer for a continuous period of 2 years. Then the maternity leave becomes paid. But if you consider a situation where you have an employee on a 2-year fixed term contract, the contract expires after 2 years, you renew, let's say, the contract. And again, to note that each contract is a standalone contract. And when you're looking at the term of service, you will not be looking at the combined years under each contract, because when a contract terminates, benefits are payable, that contract has expired, and then you enter into another contract, which would have even totally different terms. So when you're looking at the term of service, each contract is a standalone contract. So assuming that you are on 2-year contracts, you would go on your maternity leave, but depending on the terms and conditions under the law, that maternity leave, from a strict interpretation, would not qualify as paid maternity leave, because under that particular contract, chances are you may not have served for a continuous period of 2 years. So when employers are dealing with fixed term contracts and benefits payable, it's obviously important to look at those benefits which have maybe a time prescription applicable to them. And then you would want to consider whether that benefit is actually applicable with respect to the fixed term contract. Otherwise, generally, most terms would be the same. And then again, still on the benefits peculiar to fixed term contracts, like I mentioned, the main benefit is the gratuity. But we have what is called the exemption regulations. I had already touched on those earlier on. So the effect of the exemption regulations is that it exempts certain categories of employees from a gratuity or a severance pay. So for instance, employees in management and expatriate employees who are serving under a short-term contract, so fixed-term contracts whose duration does not exceed 12 months, are not entitled to gratuity or severance as of right under the Employment Code Act. So again, this is something which HR or an employer should take note. So if you have an expatriate employee or a management employee on a short-term contract, those employees are not entitled to gratuity as of right. But parties can agree that gratuity is paid. The law does not prohibit that. And then further, with respect to long-term contracts, expatriate employees, again, are not entitled to gratuity as of right. So in short, whether short-term or long-term, an expatriate employee is not entitled to gratuity as of right. With respect to employees in management under long-term contracts, they are entitled to gratuity, but the rate of gratuity can be negotiated. So it need not be the minimum 25% of the basic pay earned during the contract period. It can be 5%, it can be 10%, depending on what the parties agree to. And then employees in the agricultural sector are equally not entitled to gratuity as of right. And just as a side note, employees in the domestic sector are equally not entitled to gratuity as of right. And then if we look at termination of fixed term contracts. Maybe unlike Moemedi mentioned for Botswana, for us, the Employment Code Act, I think, is solid in that sense, because you cannot terminate a contract of employment for no reason at all, regardless of the type of contract. So the Employment Code Act mandates that every termination should have a valid reason, and this applies to fixed term. So the general rules which apply to any other contract equally apply to fixed term contracts of employment as well. So for instance, you need to have a valid reason for the termination. That reason should be connected to the capacity or conduct of the employee or based on operational requirements of the undertaking. And most importantly, if it's based on conduct or performance, an employee should be afforded an opportunity to be heard. So these are general rules which apply to any other termination, and they equally apply to fixed term contracts of employment. Again, the Employment Code Act in Section 19.3 states that a fixed term contract expires automatically on the date specified for its expiration, and no notice is required. So there's no legal obligation to notify an employee that their fixed term contract is coming to an end. So an employer can let the contract run without any notification. They would not be breaching the act. But it's obviously good practice that you have a notice period. It's good practice that you notify the employee, because from an employer perspective as well, it helps you keep your records active. It helps you plan in advance when the terminations are coming up. So it's good practice that you actually do notify your employee that the contract is coming to an end, even though you are not legally mandated to do that. Now, when we look at renewals of fixed term contracts, there is no express limitation in the Act with respect to the number of times that a fixed term contract can be renewed. So there's no provision in the Act which limits, or a deeming provision with respect to fixed term contracts. But we do have provisions which speak to casualization, and an employer would want to take this into consideration to mitigate the risk of a casualization claim. So when you look at the definition of casualization, effectively, and especially to fixed term contracts, the basis of the discussion, the Employment Code Act states that you cannot place an employee, for instance, on a fixed basis to carry out work which is permanent in nature without there being a permissible reason, if by you doing that, you are going to disadvantage the employee. Basically, that's what the Section 7.6 says. So if you are dealing with fixed term contracts, you would want to make sure that the reason you're issuing those contracts qualifies as a permissible reason under the Act, and you are not disadvantaging the employee. Going back to the earlier example, for instance, I had given on maternity leave, assuming that an employer has the tendency of issuing one-year contracts, and the reason for issuing those contracts does not fall within the permissible reasons as per Section 3, as defined in Section 3 of the Act. In that instance, I think there is a risk that an employee can claim that an employer is practicing casualization and that the employee has been disadvantaged. So you've worked for the same employer for 5 years, but the employer issues you with 1-year fixed term contracts. You will never go on paid maternity leave because each contract is a standalone contract. You've definitely been disadvantaged in that sense. And you can raise a claim that the employer is practicing casualization. When you look at the permissible reasons, there are quite a lot there. You have seasonal employment, that's permissible. You have engaging an expatriate employee, you can put them on fixed term, that's permissible. Project funded work, which is usually the case for most fixed term contracts. In Zambia, that is a permissible reason. So for an employer, you just want to make sure that if your policy is to issue fixed-term contracts, you just want to be careful as to the reason why you are issuing those fixed-term contracts, and that you're actually not disadvantaging your employees in any way. Moving to just a few practical considerations for employers when deciding whether to issue fixed-term contracts or not. I think you'd have to evaluate the true nature and duration of the work. This is speaking to the casualization I've just come from talking about. So you just want to make sure that you align the type of contracts issued with the character of the role. So you want to mitigate a casualization. And you equally noted that under fixed-term contracts, there's an additional payment of a gratuity or a severance. To note that this is in addition to what the employee would be generally entitled to under their contract of employment. So this is an additional financial obligation. So if employers are going to issue fixed-term contracts, you just want to make sure that you actually have the financial resources to pay the gratuities or the severances when those contracts come to an end. And then as well, because there's a distinction in how management employees are treated with respect to fixed-term contracts, you also just want to make sure as an employer that you properly categorize your employees as managers. So if an employee is a manager, that employee, their roles should qualify as management roles as defined in our laws. So the definition of management is not in the Employment Code Act, but you will find it in the Industrial and Labor Relations Act. So basically, that is the definition there. A person who's exercises significant authority in the company, they are decision makers. At times, we have dealt with some cases maybe where employees are alleging that they have been classified as managers when in fact they are not managers, because an employer is trying to run away from maybe their various obligations under the different labor laws. So it's important for employers to make that distinction. And then employers should also structure clear termination provisions. Obviously, a fixed-term contract has got an end date. Like I mentioned, there is no legal obligation to have a notice period, but it's good practice that you have the notice period. So these should be documented so that you know when your contracts are coming to an end. If a fixed-term contract is going to be terminated prior to its expiry, again, the Employment Code Act requires that you follow due process before those contracts are terminated. And then employer should, again, it's good practice, you conduct periodic contract audits, look at the contracts and ensure that their continued use is legally defensible, especially where employees' duties have evolved into permanent functions. So these are just a few considerations for an employer. And then with respect to reforms, there was a bill to amend certain provisions of the Employment Code Act, but this was withdrawn in July last year, I believe. To the best of my knowledge, I'm not aware of any new timelines for reintroduction of the bill. But obviously employers and HR should just monitor legislative developments, as these may have a bearing on certain provisions, possibly even on fixed-term contracts. So thank you. That ends my presentation.
Thank you very much, Jackie, and all of our other speakers. We have a few questions. Moemedi, if you would address Ritabilis and Tapelos and offences, and then there's a question from Wambu for Jackie. So if we could do that really quickly, that would be great.
Yes, thank you very much. To Ritabilis' question, in fact, that's it's quite an interesting question, because that affected Botswana US-funded agencies quite a bit as well. But what would generally happen is because these would be contracts that were still active as the time that this directive or order was issued out, the most ideal and most legally sustainable position would have been for the employer to have gone out and engaged in a retrenchment exercise through basically what we have as calling here as a Section 25 process, where employees will be consulted, then be notified of the fact that there's no longer employment because of XYZ, and thereafter, if there are alternative positions available in whatever form that maybe the agency or some instances the embassies could consider, then they will be slotted into those particular available positions. But because of the nature and the haste at which this happened, the general perception was that it was quite a rushed process where in some instances, I believe some agencies simply just shut shop without actually going through a retrenchment exercise enabling meaningful engagement with the employees. Bello's question, with this new law still to come into effect, one hopes that there would be a period specified in the regulations or something to that extent, which would state or provide a period for employers and employees to regularize for compliance going forward. That would enable employers and employees alike to engage in the requisite changes, or it might very well be that the regulations might come out simply saying that if a contract is of a fixed term nature at this point, it should be allowed to complete its course, and thereafter employers and employees could then enter into now new contracts that are binding in terms of the new piece of statute. Obviously, once you're looking at more strategic positions such as a CEO and all of that, that of course brings into question the extent that the exclusions under this particular act would come into play. There are exclusions, for example, where the act provides that you will not give out a contract of employment of a fixed term nature for 12 months or more, but there's a proviso to that which says unless an employer can demonstrate any other justifiable reason for fixing the term of the contract of employment. So whether or not the fact that someone's a CEO would count as a justifiable factor, it's really a matter for judicial interpretation in due course. With respect to offense, the minimum fixed term contract duration in Botswana, we're looking at 12 months. What the Employment Act envisages is that no one should be placed on a fixed term contract of more than 12 months unless there are exceptions that are provided for under the Act which do arise. For example, if it is a construction project, for example, and it does have a period, a commencement date and an end date of maybe 24 months, those would fall within the exceptions that the Act does envisage. So there are indeed exceptions, just like my colleagues have already submitted as they presented, that would apply to fixed term contracts as well. And those would be amongst the exceptions that have been expressly stated in the Act, should it come into force. Thanks, Claire.
Thanks very much, Moemedi, for that condensed and concise response. I hope that answered your questions. Jackie, did you have a chance to look at the question from Wambu?
Yes, I have. What is the probable rationale of excluding domestic workers from gratuity in Zambia? I would want to think that maybe it's because domestic workers have some sort of pension benefit guaranteed in the domestic workers order. I don't have it in front of me, but I believe they're entitled to, is it 2 months pay or 2 months basic pay for each completed year of service. So they are entitled to a payment in recognition of their term of service. I would want to assume that may be the reason why they excluded gratuity, because when you look at gratuity as well, the whole reasoning behind it is to recognize the term of service. And the domestic workers order already has a similar recognition in there. I would want to assume that would be the reason.
Thank you very much. Just quickly, I'm going to start with Keshni. Nazreen has a question. Well, this will be our last question. With a fixed term contract, what is the notice to be given to renew or terminate? Keshni, if you can kick off from a South African perspective, please.
So from a South African perspective, there's no sort of statutory provision insofar as notice. You don't need to give any, because the term of the contract is fixed, and it's agreed up front that there's no expectation of renewal. There's technically no reason or there's no need to give notice that you're not going to renew or that you're going to terminate. We've had instances where, for example, someone is employed in another country, they're on an assignment to another country, and that would then require them to make arrangements to relocate or to move back home and to move their belongings. And there it would just be obviously reasonable, and the right thing to do would be to give them notice and allow them time to move back. So it will depend on the duration of the fixed term contract. Where a contract is, for example, a year long, I think that a 1 month's notice or 2 months' notice is reasonable to notify an employee, even though you've said up front that there is no expectation of renewal. I think 1 month's notice in that instance would be reasonable.
Thank you, Keshni. I think Nazreen only wants a Botswana perspective now. So, Moemedi, if you could quickly answer that, and Jackie, you let off the hook.
All right, yes. Nazreen, the exact same position that Keshni has just stated actually applies to Botswana as well. Because the contract is of a fixed term nature, it means the term itself is definitive of the duration. So if the contract will lapse come the 31st of December 2025, there is no legal requirement for you to maybe on the 1st of December, for example, give the employee notice that the contract will be coming to an end. To the extent that that has not been done, no notice has been given, the contract will automatically, through the fluctuation of time, come to an end. And likewise for a renewal, if the employer during the subsistence of that particular fixed term contract elects that they are desirous of renewing the contract, they would simply have to notify the employee. It could even be the day before that the contract lapses, that you notify the employee of the intention to renew or extend that particular contract. So there is no statutorily defined or stated period in terms of the law in Botswana either.
Thank you. Thank you for answering the questions and asking them questions and your engagement. I'm just going to quickly, we're going to take 1 minute to just do an announcement, and over to you, Moemedi.
Yes. First, I'd just like to thank everyone that's come on board this afternoon. We sincerely do appreciate it. We can see that there's really so much more that could be said. And we assure everyone that is here and those that have not been able to join in today, unfortunately, for varying reasons, that there will be ample opportunity. As you can see on the screen now, there will be an African Labour Law Society conference. This will be our 7th conference that will fortunately enough be held in Botswana on the 25th and 26th of February next year. More information will definitely be shared across all social media platforms. And we really, really would implore you all to please be in attendance. It is such an amazing platform to join in. There would be great discussions. There will be side discussions. There will be opportunities for you to engage with the speakers. There'll be opportunities for some of you, if are interested in, to possibly even sign up as speakers for this conference that will be taking place in Gaborone next year. So from my end, as the president and the rest of the panel today, we'd like to thank you for having been with us this afternoon. And we sincerely wish that you take what we've discussed today and look forward to seeing you and having you join us in Gaborone next year. Thank you very much.
Thank you. Thank you very much. Thanks to all the speakers. And we'll share the announcement with all of you who have registered to attend today. So thank you for your amazing support. And there are a lot of people from Botswana on this call, so we look forward to seeing you in person. And it's great to have been able to present such an important and useful webinar to our members and community. So thank you again to the speakers who have been amazing, and to Connor for the behind the scenes work, and to all of you for joining us this afternoon. If you're in the Southern Hemisphere, stay warm and well, and we look forward to seeing you in person in Botswana, but we will have another webinar before then anyway. So thank you, speakers. Thank you, Connor. All the best to all of you.
Thanks, everyone.